Hi, this is Joel Persinger. I'm the gun guy. Thank you very much for watching my videos. I really do deeply appreciate it. I'm going to update you a little bit on California law today, but before I get started, let me mention a few things. One, if you're interested in knowing what the California laws are as they've changed through Gunmageddon and the various propositions and so on in California, then I urge you to check out the videos I've done before. If you post questions about the things I've gone over in other videos, in this video, I honestly, as much as I'd love to be able to answer all of those for you and save you having to watch the video, I just can't. This is not my full-time job. I actually work for a living, and I do have a wife and kids and so on. So I'm doing the best I can. I would urge you to go ahead and watch the videos I've already done on those subjects. And I will post in the description links to those videos so that you can easily find them. There's also the webinars that have been put on by the California Rifle and Pistol Association, which is the California arm of the National Rifle Association. They've done a great job in those webinars, and what I'm going to tell you today is what I've gleaned from one of those webinars. I'll also put the links to those webinars in the description, and I urge you to go watch them, irrespective of what you hear here. I am obviously not an attorney. It's not what I do for a living. I'm a California gun owner and a longtime firearms instructor, but I'm not a lawyer, don't want to be one, and I don't play one on TV. So I'm basically giving you my understanding that I've learned from various different places, including the California Rifle and Pistol Association webinars. So again, I urge you to check those out. And if you check in the description, that's where you're going to find the links for those. All right. Now, today I'm going to cover the process of how it works in California and where we are. So before I say anything else, let me let you know there's kind of a three-phase or three-part process as I understand it. The first part is the law has to be made law. Well, we have a whole bunch of brand new firearms laws in California, God help us all. And if you're not from California, I urge you to watch the video anyway so that you know what might be coming to your state, because as we all know, it often happens in states like California, and then it gets pushed throughout the country. We're seeing that right now in Nevada. There's a lot of people moved there from California trying to infect that state. We've seen it happen in Colorado. We see it happen in Oregon and Washington. If you're in a free state right now, I urge you to keep it free, and the best way that you can do that is keep yourself informed and take preventative action wherever you can. So it's good that you're watching this, even if you're from a free state. And if you are, congratulations. I'm grateful that you're there. All right, now what happens in California is the law passes, and either passes through referendum, which means it becomes a ballot initiative, which is what happens recently, and then it's law, or it goes through the legislature and the governor signs it, and then it becomes law. After laws happen, then the Californians, particularly if they're, I should back up, I'm sorry. After laws happen that involve criminal law, they then go to the California Department of Justice so that the Department of Justice can issue regulations explaining how they intend to enforce that law and what the specific rules are for citizens who want to follow the law. Those would be law-abiding citizens, and how and what they need to do in order to abide by that law. Those are regulations. Now, regulations don't become law until they've been reviewed by the California Office of Administrative Law, the OAL, and then once that happens, while they're in review, they are available generally for public review and public comment, and there's a public comment period, except in the case of emergencies. I'll explain that in a minute. Once it's gone through public comment, been changed, withdrawn, altered, updated, whatever, then it will be published, and once it's published in the California Code of Regulations, it then becomes law. Well, here's where we are in the process. The laws have already been passed on the ballot and signed by the governor, two different sets of laws, a little conflicting, but I've gone over them in previous videos. And now the California Department of Justice has proposed its regulations and sent them to the Office of Administrative Law, the OAL. And while they're there, there's time for public comment. But the DOJ is now trying to create law rather than just make registration, or rather than just enforce the law that's already been put on the books for registration. Now I'm going to put this up on the screen for you so that you can see what the various regulations that they proposed are. Now, if you think this is complicated so far when I've just shown you a list, wait till you see the rest of this. For example, the current Code of Regulations that has already been adopted years ago has 5 definitions related to assault weapons. The new Code of Regulations that DOJ is proposing has, are you sitting down, 44 definitions associated with assault weapons. 44 different things we have to wade through to figure out whether we actually have an assault weapon or not, as opposed to 5. I'm just going to say it. I think this is an effort by the California government to make owning a defensive rifle or any kind of modern sporting rifle or AR-15 or anything like that so difficult because it's impossible for citizens to navigate these complicated laws that people will just give up. Well, I'm just going to put the government on notice right now. I, for one, am not giving up. I'm going to figure out how to do it. I'm going to try to do it legally. I'm going to do my best, and I'm going to own a gun anyway, even though they don't want me to. And then I'm going to do my absolute utmost to see these laws rescinded and changed, and the rights of Californians under the Second Amendment restored in full. Now, with that, let me explain a couple of these things to you. First of all, assault weapons have to be registered, but what the heck is an assault weapon? And that's where you get into some of these definitions. So the new regulations actually would say centerfire, a semi-automatic centerfire firearm, rifle, pistol, shotgun. Now, nowhere in these new laws that were just passed was anything changed with regard to shotguns. It was only rifles and pistols in some respect. But shotguns were never listed there as being changed at all. The law regarding shotguns has not changed, and yet DOJ has inserted them in here, even though the law didn't change. So what they've inserted in here is that a semi-automatic centerfire firearm, rifle, pistol, shotgun, with an ammunition feeding device that can be readily removed from the firearm with the use of a tool commonly referred to as a bullet button weapon, that has one or more specific features identified in Penal Code Section 30515, that's the pistol grip, collapsible stock, flash hider, and so on, is included in the category of firearms that must be registered. This specifies that semi-automatic shotguns, in addition, are part of this regulation, but they're not part of the legal changes. All right, let's look at detachable magazines. The definition of a detachable magazine hasn't changed much, except that they've specified a couple things. The previous definition is roughly the same. However, they have changed in the regulation the following. An AR-15 style firearm that has a bullet button style magazine release with a magnet left on the bullet button constitutes a detachable magazine. So if you screw up, or I screw up, and you got one of those little bullet button magnets, I've got one, and you leave it on the bullet button, then that now constitutes a detachable magazine, and that is an unregistered assault weapon. For that matter, if you've registered it as an assault weapon and it has a bullet button, you can't change the bullet button out, apparently. And if you leave that magnet on there, that's also a violation. Now, with regard to detachable magazines, and what does disassembly of the firearms action actually mean? Well, this is what they've proposed in these regulations. Disassembly of the firearm action means the fire control assembly is detached from the action in such a way that the action has been interrupted and will not function. And this is written by the DOJ. For example, disassembling the action on a two-part receiver like that on an AR-15 style firearm would require the rear takedown pin to be removed, the upper receiver lifted upwards and away from the lower receiver using the front pivot pin as the fulcrum before the magazine may be removed. To me, that appears to validate the AR Maglock device and the Franklin Armory DFM magazine as being legal, and it would make it essentially a non-detachable magazine because you couldn't take the magazine out without first pulling that pin and rotating the action forward, the upper forward, to get to the lower. So that sort of answers that question. But again, this is not law. These are just proposed regulations as far as they've gone with it. All right, flash suppressor. This is one of my biggest concerns. What does flash suppressor actually mean? Well, they've made it even more vague than it was before, and it was vague enough as it is. I'm going to put this up on the screen for you because I want you to see how vague this is. Flash suppressor means any device attached to the end of the barrel that is designed, intended, or functions to perceptibly, what does that mean? Perceptibly reduce or redirect muzzle flash from the shooter's field of vision. Well, who defines perceptibly? What's perceptible? A hybrid device that has either advertised flash suppressing properties or functionally has flash suppressing properties. Well, what constitute flash suppressing properties? Would be deemed a flash suppressor. So even if it doesn't suppress any flash, but the manufacturer puts in there that advertises that it does, it's a flash suppressor. A device labeled or identified by its manufacturer as a flash hider would be deemed a flash suppressor. Well, now look, just because a manufacturer calls a device a flash suppressor in their manual doesn't cause it to meet the California definition of that term. So this is so vague as to be criminal, to use a turn of phrase. It's a criminal law that in my mind is criminal. This thing essentially describes and defines a flash suppressor in such vague terms that it could be anything. I could have a muzzle brake, I could have a compensator, but if it in any way, under anybody's opinion somewhere along the way, or some cop says, well, that hides the flash a little bit, that's a flash suppressor. You can't win. At the P2K Range, I was there the other day, they put a Thorston stock on one of their rental rifles and took a hacksaw and cut the flash suppressor off the front. And that's the gun they're renting, because they were so afraid of having anything screwed onto the front of that rifle that any cop anywhere could wrongly construe as being a flash suppressor. They just cut the stupid thing off the front end. This is one of the reasons I did the review a few days ago on the Franklin Armory DFM magazines. One of the reasons why anytime the rifle is in the safe or anytime it's in my car going from point A to point B, even though it's going to be a featureless rifle when I get done, I'm putting that DFM magazine in it, because if some cop decides that my muzzle brake or my compensator is a flash hider and they start pulling on that magazine, then they're not going to be able to arrest me because it's got a fixed magazine. When I get to the range or wherever I'm going, I'll take a quick scan around to make sure I'm not going to get accosted by somebody, and then I'll take it out and then use it as a featureless rifle and shoot it that way. But at least when I'm transporting, I'm going to use the DFM magazine to cover me there. It's always locked in my trunk anyway, and I don't consent to searches. But if some cop were to see it, that keeps me from getting arrested because of this flash suppressor thing, which is enough to drive anybody nuts. This is something that NRA, CRPA et al. Are going to be fighting as well. I can tell you that for sure. All right, permanently attached. I've had a number of questions about people who want, for some reason, to permanently attach a fixed magazine to their rifle. Not in the way we've just talked about. This is, permanently attached, like a magazine in an M1 Garand or something like that. It's not going to be removable anymore. What they have done in these regulations is defined permanently attached, if that's something you wish to do. If you've got a rifle that you want to do that with it. Permanently attached to means the magazine is welded, epoxied, or riveted into the magazine well. There you go. Those are your choices. Welded, epoxied, or riveted into the magazine well is what the regulation says so far. Again, these things are not law yet. These are proposed regulations that are currently at the Office of Administrative Law and are being open for public comment at the moment. All right, now I get a million questions about 80% lowers and so on. And they've made this very, very vague. Are you surprised? I'm not. All right, I'll just read it to you because here you go. Unfinished receivers. And I'll explain to you where the vagueness is just amazing here. Receiver unfinished, quote unquote, means a precursor part to a firearm that is not yet legally a firearm. What the heck is a precursor part? And exactly which part is that? That could be any part. That doesn't necessarily have to be the receiver. That could be anything. A precursor part to a firearm that is not yet legally a firearm. That means nothing. Okay, that's whatever you want it to be. And they go on. Unfinished receivers may be found in various levels of completion. Duh. As more finishing is completed, the precursor part gradually becomes a firearm. Double duh. Some just have the shape of an AR-15 lower receiver, for example, but are solid metal. So that's just a block of metal. But it qualifies as a precursor part to a firearm that is not yet legally a firearm. It might not even have anything milled out. It might not even have a hole drilled in it yet. But it's just a solid block of metal. So if I go down to the junkyard and I buy a block of steel and it happens to look like an AR-15, I guess that's what that means. What the heck is a precursor part? What does it mean? What is an unfinished part? What does it mean? Which part are we talking about? What does that mean? Are we talking about all parts, just receivers? What are we talking about? And at what point does it gradually becomes a firearm? How? When? What's the process? At what level of completion is it now illegal? At what point is it just a block of metal, and at what point is it now illegal? This is about as vague as you can get. And this, again, is stuff that the NRA and CRPA, with their attorneys at Michel & Associates, are battling. All right, semi-automatic. What the heck does that mean? Semi-automatic means a firearm functionally able to fire a single cartridge, eject the empty case, and reload the chamber each time the trigger is pulled and released. Further, certain necessary mechanical parts that will allow a firearm to function in a semi-automatic nature must be present for a weapon to be deemed semi-automatic. Okay. A weapon clearly designed to be semi-automatic but lacking a firing pin, bolt carrier, gas tube, or some other critical part of the firearm is not semi-automatic for the purpose of Penal Code sections, whatever they are, 3515, 3600, and 34605A, and 3900, in case you want to know. I'm going to put this up on the screen for you because it's kind of interesting. All right, now they have some subsections. Subsection 1. By the way, before I go on, that little part right there tells me that if you take the bolt carrier out of the gun and put it in your safe, it's not semi-automatic, so it's not an assault weapon. Now, I'm not an attorney, okay? That's all I'm saying. If it's not an assault weapon because it doesn't have a bolt carrier in it. There's no bolt carrier group. Right? So you want to keep it around for, major natural disasters or something, and you don't want to register it, and you don't shoot it much. Take the bolt carrier group out, put it in the safe. It's not a gun. It doesn't work. I don't know. That's what I'm reading here. I could be completely. Don't take that as legal advice, please, because I'm just trying to figure this out too. All right, subsection 1. A mechanically whole semi-automatic firearm merely lacking ammunition and a proper magazine is a semi-automatic firearm. 2. A mechanically whole semi-automatic firearm disabled by gun lock or other firearm safety device is a semi-automatic firearm. Parentheses, all necessary parts are present once the gun lock or firearm's safety device is removed and the weapon can be loaded with a magazine and proper ammunition. So as a result, it's still semi-automatic. All right, 3. With regards to an AR-15 style firearm, if a complete upper receiver, this is a big deal, if a complete upper receiver and a complete lower receiver are completely detached from one another, but still in the possession or under the custody or control of the same person, the firearm is not a semi-automatic firearm. I had to read that about 3 times to see if that was right. So if I pop the 2 pins and pull the upper off the lower, even though it has all the features and everything else, and they're separate, and even though I have them both in my possession, the way this is written, if I'm reading it right, that is not a semi-automatic firearm. Now I'm going to put this verbiage up on the screen for you so you can see it and you can read it the way you feel you want to. But that's the way I read that. Again, I'm not an attorney, but that makes sense to me. All right, a stripped AR-15 lower receiver, when sold at a California gun store, is not a semi-automatic firearm. The action type, among other things, is still undetermined. Now, this definition suggests that firearms must be functionally and fully assembled in order to be considered assault weapons. If they're not functionally fully assembled, then they're not. Who knew? That's interesting from a storage perspective, isn't it? Or a transporting perspective, for that matter. All right, here's some weapons that will not be registered, and then I'm probably going to wrap up this one, and we'll finish another one on another video, because otherwise I'm going to bore you to tears. All right, under the new regulations, firearms that will not be registered. Firearms sold after January 1, 2017 If you got them after that, you can't register them as assault weapons. You're going to have to make them featureless. If you got them after that in California, they're going to come featureless anyway. And then you can't make them full-featured because then you have an illegal assault weapon and you can't register it. Firearms required to be registered under prior assault weapons registration laws in effect before January 1, 2017. All right, hold up. Let me stop right there. If you have a gun that is an assault weapon under previous laws, don't go down and try to register it, okay? Find an attorney and talk to them before you do that. Get the advice of a qualified attorney that specializes in firearms law in the state of California. Because if you take a gun that was subject to registration prior to these new laws and was never registered, then you've had a gun that was against the law and probably a felony for a very long time. And if you march down there to register it, or you get online to register it and it pops up as something you should have registered before, you're going to get on your doorstep and you're going to find yourself in handcuffs with a police officer saying, "Watch your head," as he's putting you in the car. So I just want to urge you, if you have one of those, do not try to register it. Instead, contact an attorney to get some advice before you do anything. And I'm not going to advise you to do anything illegal. I cannot do that. So I'm just saying, follow the law, but do not go down and try to register something that you now know was illegal before this law started, because you're going to get arrested for violating the previous law. And I'm kind of concerned that people are going to race down and try to register these things that they didn't register before. They know they should have, and now they see this as some form of amnesty. It's not. It's not. This is not an amnesty program. If you were breaking the law before, don't try to register that gun, because you're going to get popped for it. And there you go. All right. Featureless firearms will not be registered. So make your rifle featureless. Make your rifle featureless. Make your rifle featureless. That's what I urge people to do. That's what I'm going to do. No, I will never dance on this show again. That's it. All right. Firearms that have a fixed magazine that holds 10 rounds or less. There you go. Firearms that are not fully assembled and fully functional. Firearms manufactured by a federally licensed manufacturer if the firearm does not have a serial number applied under federal law. Firearms manufactured by an unlicensed subject if the firearm does not have a serial number assigned by the Department of Justice, and then attached to the firearm. By the way, the serial numbers are required now in California for all firearms, so don't think that excludes you from adding the serial number. They just won't register it unless and until you add it. And you'd have to do that before January 1. All right, let's continue with that. Other things that will not be registered. Firearms sold after... Oh, I did that already. Hold on. There you go. All right, what are you going to have to include in your application? This is kind of crazy. I'm going to put this up on the screen for you, too. I listed all this stuff before. This is the standard stuff that you would think they would want in an application. Your full name, address, telephone number, date of birth, sex, height, weight, eye color, hair color, and so on. But they also want your military identification number if you have one, your California driver's license number or identification card if you have one, your U.S. citizen status, your place of birth, your country of citizenship, and alien registration number or I-94 if applicable. This stuff that I just listed, starting with military ID, California driver's license, California ID card, U.S. citizenship status, place of birth, country of citizenship, alien registration number, and so on. None of those are required by the laws recently passed by the legislature or voted into law. This is all stuff that DOJ is just inventing. Now, a lot of that, in fact, I think all of that is on the dross when you buy a firearm. But they've just kind of put it in there because they feel like they can. So as you can see, this stuff is really pretty darn bad. I mean, it's really awful. And let's hope it doesn't come to a state near you if you're not in California. I'm going to wrap up with the rest of the information. As you can see, there's a lot more. I mean, this is just, I've kind of scratched the surface here. It may take 1 or 2 more videos to get this all done for you, because if I put it in one, you're going to pass out from boredom probably. And I don't want to do that to you, so I'm not going to do it. We'll finish it up in the next couple of videos. Please keep in mind that the best thing that you can do if you're in the state of California is join the National Rifle Association, join the California Rifle and Pistol Association, join other organizations that fight in California. Now, look, I'm a fan of the NRA, CRPA, Gun Owners of America, the Second Amendment Foundation, the Firearms Policy Coalition. They're all awesome. And if I had the money, I would join them all, but I don't. I'm an average blue-collar working stiff, and I haven't got that kind of dough. However, I can be a member of the National Rifle Association and support CRPA. Those organizations are all great, but let's face it, the NRA is the 600-pound gorilla in the room, and that's the one that you should join if you can only join that one. So I want to urge you to please join the National Rifle Association. And you should know that every dime contributed to the NRA and the California Rifle and Pistol Association in California stays in California. If you don't think they do anything, and you have people come along and say, the NRA doesn't do anything, the NRA forgot us. Look, I'm going to put a link in the description where you can go find out the kind of things the NRA and CRPA have been doing, the lawsuits they've had, the successes they've had. You'll see them all there. And you can check them out for yourself rather than listening to people on YouTube. I also urge you to join other organizations if you can. Gun Owners of California is awesome. Sam Paredes does a lot of work around here, so support him as well. There's some great organizations out there, but the number one thing you should do if you haven't joined anything else is the NRA. Because the NRA and the California Rifle and Pistol Association, its California affiliate, do a lot of work in California, and they need your help. There's a lot of coming lawsuits about this stuff, and lawsuits cost money, and they need membership to support them. All right, so in order to help you do that, I've put a link in the description for you to join NRA. It will save you a little bit of money. You can join the NRA for a year for less than the cost of one box of ammunition, and don't let anybody talk you out of it. Likewise, if you have a firearm for home defense or you carry a gun every day like I do, and you might ever have to use it to defend yourself or someone you love, you're going to have legal challenges whether you're in California or a free state. It's important for you to have backup so that you can defend yourself in civil suits and criminal actions. The company I use for that is called Second Call Defense. They're a great company. I have used them for a long time. I've been talking about them for a long time, and so much so that they actually started supporting the channel. I'm really grateful for that. But I want you to know that they support the channel a little bit, but I've been talking about them a long time before they started doing that. So I'm not talking about them because they're paying me. I'm talking about them because they're great. So check out Second Call Defense. There's a link in the description for that too. It'll take you to a special part on our website where you can check them out. Thank you again very much for watching my videos. You have no idea how much I appreciate it. I want you to know right here and right now that you're awesome. Don't let anybody ever tell you any different. You're loved by God and deeply appreciated by me. Have a great week, and please be safe.